Friends, I am Vijay Kumar, Deputy Secretary in the Government of India. On Delegation of Financial Powers Rules 1978. This is my third and final talk. In this talk, I will discuss rules 4, 10, 11, 13, and 18, which are not only lengthy but also complex. However, before I take up these rules, I would like to give a brief account of the financial machinery of the Government of India. We very often hear the word governance. What is governance? Governance is, in essence, nothing but the governance of finance. Government is the supreme manager of country's financial resources. Only government knows from where money comes and to where money should go. Therefore, it would be appropriate to be familiar with the apex financial machinery of the government. The noted and familiar apex financial players are Finance Ministry, which is the nodal ministry, secretaries of ministries, departments. They function as chief accounting authority, financial advisors. They are representatives of finance ministry in each ministry department. Internal finance wings in each ministry department. These wings are manned by directors finance, deputy financial advisors, assistant financial advisors, etc. Heads of various departments of government, heads of offices, drawing and disbursing officers, pay and accounts offices in each ministry department, principal accounts officers, they are for reconciliation of accounts, pay and account officers, Controller Generals of Accounts, also known as CGS. I understand you must be familiar with most of them. Now let us take up the rules. First, Rule 4. This rule puts limitations on the powers of the subordinate authority to sanction expenditure. This rule provides that no expenditure shall be incurred from the public revenues except on legitimate objects of public expenditure. Also, a subordinate authority may sanction expenditure or advances of public money in those cases only in which it is authorized to do so by the provisions of any law for the time being in force or any other rules issued by or with the approval of the President or any general or a special order of the President or other competent authority. No subordinate authority can sanction any expenditure which involves the introduction of a new principle or practice which is likely to lead to increased expenditure in future unless the said expenditure has been subjected to a scrutiny and agreed to by the Finance Ministry before its inclusion in the budget. A subordinate authority shall exercise the power to sanction expenditure subject to any general or a special order, direction or a stipulation which the authority delegating or re-delegating such power may issue or prescribe from time to time. As such, the limitations prescribed by this rule include authority of law or written rules or orders issued by the President only. A scrutiny as well as concurrence of Finance Ministry and moreover legitimate objectives which in essence means parliamentary control, etc. A very comprehensive exercise and a scrutiny of things is undertaken at the level of ministry department for the determination of legitimate objectives of public expenditure. Internal Finance Wing and Ministry of Finance are also involved in this exercise at various stages. Through various meetings, seminars, debates, the policy and the scheme are formulated. Then institutional and implementation mechanisms are designed. Then financial implication is assessed. Then EFC, SFC, CCEA, cabinet approval as applied in the situation is obtained. Then after it is submitted for approval of the Parliament. Only after the approval of the Parliament, the objective of public expenditure receives legitimacy. Now Rule 10. Expenditure control can be ensured only through the proper accounting of expenditures, which in turn ensures proper audit of expenditures. With this end in view, Rule 10 provides for restrictions on appropriation or reappropriation. There are also important decisions of the Government of India below this rule, and those decisions need to be taken into consideration for better understanding of this rule. Rule 10, read with the decisions of the Government of India below it, in essence prescribes the following three kinds of restrictions. First, omnibus restrictions, that is, where appropriation or reappropriation is not permitted at all. Second, where appropriation or reappropriation is permissible only with the approval of Ministry of Finance. Third, where ministry or department itself is competent. First, omnibus restrictions. These restrictions include: first, restriction to meet an expenditure not sanctioned by the competent authority. Second, restriction to meet a votable expenditure from charged expenditure and vice versa. Third, restriction to meet an expenditure of one grant of charged expenditure by reappropriation from other grant of charged expenditure. Fourth, restriction to meet an expenditure on new service or new instrument of service not contemplated in the annual financial statement passed by the Parliament. Fifth, restriction to meet an expenditure from and to travel abroad of scientists. Sixth, restriction to meet an expenditure on public work which did not receive administrative approval or technical sanction. Seventh, restriction on reappropriation of funds from capital section to revenue section and vice versa. Eighth, restriction on reappropriation of funds from salaries to any other head. Ninth, no reappropriation is permissible from the funds allotted to externally aided projects for non-externally aided projects. 10. Restriction to meet an expenditure on a public work not included in the budget which is costing rupees 50 lakhs and above. Now, appropriation or reappropriation which are permitted only with the approval of Ministry of Finance. These include: first, restriction on transfer of fund from plan to non-plan. Second, restriction on transfer of fund from and to secret service expenditure. Third, restriction on transfer of fund from any provision made for new service or new instrument of service. Fourth, restriction on transfer of fund to augment secretarial expenses. Fifth, restriction on transfer of fund from capital outlay to loans and vice versa. Restriction on transfer of fund to meet an expenditure relating to public work costing rupees 10 lakhs and above but less than rupees 50 lakhs. Seventh, restriction on transfer of fund from major works to other unit. However, the department is competent to appropriate on allied grounds like major works, minor works, repairs and maintenance. Eighth, restriction on transfer of fund to augment salaries, wages, office expenses and other charges taken together. However, Ministry of Information and Broadcasting can reappropriate from and to allowances to artists within this group. Ninth, restriction on transfer of funds to increase the provision under travel expenses exceeding 10% of the existing provision. 10th, restriction on transfer of fund to meet an expenditure on works in excess of 15% limit, subject to the condition that the savings are available under the work head. Two additional items have been added recently under this head. First, no diversion of funds for travel expenses, even from secretariat expenditure. Second, no diversion of funds from other heads to secretariat expenditure. Now, cases where ministries, departments have full powers for reappropriation. First, from non-plan to plan if no foreign exchange is involved. Second, from plan to plan if no foreign exchange is involved. Third, increase in travel expenses up to 10% of the total provision by reappropriation from other heads. 4. An expenditure on public work costing less than rupees 10 lakhs, even if it is not included in the budget. The Government of India had announced in 2016 that the classification of plan expenditure and non-plan expenditure will be abolished. Accordingly, the plan and non-plan classification was removed from 2017-2018 and the expenditures of the government are now being classified as capital and revenue spending. Plan expenditure pertains to the money to be set aside for productive purposes like various projects of ministries. The government decided to do away with the distinction because of the abolition of the Planning Commission, as the relevance of plan and non-plan expenditure was lost. Prior approval of the Parliament for expenditure from the consolidated fund is required. For setting up a new undertaking, taking up a new activity by an existing departmental undertaking and involving capital expenditure, for setting up a new public sector company, for a splitting up of an existing company or amalgamation of two or more companies. For taking up a new activity by an existing company, in respect of investments to be made for the first time in private sector companies or private institutions, except in units coming under government management with the approval of Parliament. Approval of the Parliament is also required in the cases of additional investments above rupees 1 crore in an existing undertaking, oblique private sector companies, private institutions. And in the case of additional investments in loans above rupees 20 lakhs to an existing public sector company where there is no budget provision. In the cases where there is budget provision and paid up capital of the company is between rupees 1 crore to rupees 100 crore, the limit for seeking approval of the Parliament ranges between above 20 lakh to rupees 15 crores. The expenditure below the limits of Parliament for approval can be made from the reappropriation of savings in a grant subject to report to the Parliament. Expenditure above rupees 10 lakhs and up to rupees 50 lakhs on new works, land, buildings, and oblique or machinery can be made from savings in a grant by reappropriation subject to report to Parliament and with the prior approval of the Parliament if it exceeds rupees 50 lakhs. In the case of grant in aid to statutory and other public oblique private institutions under revenue expenditure, the prior approval of the Parliament for meeting the expenditure out of the Consolidated Fund of India is required above the following limits. First, for the institutions in receipt of grant in aid above rupees 1 crore, rupees 10 lakh limits apply with reference to money disbursed by an individual, ministry, oblique department, and not by the government as a whole. Second, institutions in receipt of grant in aid above rupees 1 crore, 10% of the budget provision or rupees 2 crores, whichever is less. Third, grants in aid to private institutions other than for export promotion schemes, recurring, above rupees 5 lakh. Fourth, grants in aid to private institutions other than for export promotion schemes, non-recurring, above rupees 10 lakhs. Fifth, write-off of government loans above rupees 1 lakh, individual case, has to be referred to the Parliament. Now, Rule 11, which is about the creation of posts. The need for creation of posts arises when a new organization is set up, when an existing organization expands, on reorganization of the structure of an organization after detailed study, to fulfill certain statutory functions, upgradation of posts for various regions, workload and functional justification, and matching savings are sought at the time of creation of posts. Not only this, creation of posts involves observance of many principles. Rule 11 of DFPR provides that no post shall be created in the Secretariat Office oblique Department of the Central Government unless the scale oblique rate of pay on which the post is created has been approved by the President. No post on permanent basis can be created without the previous consent of the Finance Ministry. The subordinate authority authorized to create a permanent post may create similar supernumerary post for the purpose of accommodating the lien of a government servant who, though entitled to hold a lien against regular permanent post, cannot be so accommodated because of non-availability of such a post. The supernumerary post has to be created only if another vacant permanent post is not available to provide lien. The power conferred on a subordinate authority to create permanent or temporary posts shall not, unless otherwise directed by the President, be exercised so as to aid such posts to any service or cadre unless that service or cadre is under the control of that authority. In addition, creation of temporary posts is possible by appropriation oblique reappropriation. Retrospective creation of posts can be done with the approval of Ministry of Finance. Creation of joint secretary or above level post can be done with Cabinet's approval only. Rule 13 of DFPR provides in respect of various powers to subordinate authorities such as creation of permanent posts, temporary posts, appropriation and reappropriation, incurring of contingent or miscellaneous expenditure, write-off of losses. These powers are specified in Schedules 2 to Schedule 7 of these rules. Schedule 2 provides powers to subordinate authorities to create permanent posts. Schedule 3 provides powers to subordinate authorities to create temporary posts. Schedule 4 provides powers to subordinate authorities in respect of appropriation and re-appropriation. Schedule 5, along with its annexure, provides powers to subordinate authorities in respect of incurring contingent expenditure. Schedule 6 provides powers to subordinate authorities to incur miscellaneous expenditure. Schedule 7 provides powers to subordinate authorities to write off losses. A department of central government may, by general or special order, confer powers not exceeding those vested in that department upon an administrator or head of department or any other subordinate authority in respect of any matter covered by these rules. However, no powers can be delegated to any subordinate authority in respect of creation of posts, write-off of losses, and reappropriation of funds exceeding 10% of the original budget provision for either of the primary units of appropriation head, appropriation subhead. Powers to write off losses may be exercised by a subordinate authority provided that a. The loss does not disclose a defect in rules or procedure. The amendment of which requires the orders of higher authority or finance ministry. B. There has not been any serious negligence on the part of any government servant which may call for disciplinary action by a higher authority. Rule 18 is about expenditure on schemes or projects. Subrule 1 of this rule provides that a department of the central government may sanction expenditure on any scheme or project, the total outlay on which does not exceed rupees 1 crore 50 lakhs if the scheme has been approved by the finance ministry. The limit includes the entire cost of the scheme up to the date of completion, both recurring and non-recurring. Cost of the works, even where the provision for such work is made in a demand under the control of another department. Approval of the finance ministry shall not be required to sanction excess expenditure over the original estimates of a sanctioned scheme up to 10% or rupees 5 crores, whichever is less, in the case of plan scheme, and 10% or rupees 3 crores, whichever is less, in the case of non-plan scheme. The powers to sanction expenditure on schemes in respect of the departments of central government having integrated finance advice system under plan schemes have been enhanced to schemes costing less than rupees 100 crores, provided the scheme has been accepted by the Ministry of Finance at the pre-budget stage. The increase in the cost will be approved by the administrative ministry or department in consultation with the planning commission, since dissolved with effect from 1st January 2015. Budget division of Ministry of Finance, where such increases are due to a. Increase in statutory levies, b. Exchange rate variations and price escalation within the originally approved project time scale. Refer Government of India's decision 4 capital A3 below this rule. That is Rule 18. Sanction of non-plan expenditure. A department with integrated finance scheme can sanction non-plan expenditure on schemes costing less than rupees 300 crores with a specified financial limit by the prescribed authority, but no non-plan post would be created under this power. Refer to Government of India decision 4 capital B below Rule 18. Ministries or departments of the central government may issue expenditure sanction in respect of major works costing up to rupees 5 lakhs without consulting the Ministry of Finance. Refer to Government of India Decision 7 below Rule 18. In brief, this is about Rules 4, 10, 11, 13 and 18 of the DFPR. With this talk, the discussion on DFPR concludes. I will begin discussion on General Financial Rules 2017 in my subsequent talks. Thanks for patient listening.